Morning, folks.
Morning.
How's everybody doing today? Great. Glad to hear it. It was on this date in 1787 that 12 states signed the Constitution of the United States. And since then, it has been and is the oldest working constitution on the planet. That says a lot for our founding fathers in the way they constructed it and the way it has been executed ever since. Today is Constitution Day. It is mandated by the federal government so that you folks get a better understanding of the Constitution, what it means, and what effect it has on your lives. So therefore, every school is mandated to hold some event. Thus, this event for you. Because we have found that particularly young people who have not been exposed to U.S. history or even world history to a great extent are woefully lacking in knowledge of the Constitution. We hope to correct some of that today. As our guest speaker, we have invited Judge Thomas Padrick. He sits on the Circuit Court in Virginia Beach and deals with the Constitution every day. Judge Padrick started out as a police officer, became an attorney, and then was appointed to the bench. So if you would please, welcome to the lectern, Judge Thomas Padrick.
He didn't tell you that the two of us were on the police department together many years ago.
Way long.
Back in the day. This is going to be real informal, and because I have to go to court in about an hour. Now, I don't know how much knowledge you have about the court system or how the Constitution works or anything like that, but I will tell you, if you get into trouble, just to start at the front and move back, I'm like your last clear chance before you go to prison. Strange as that might sound. I'm not saying anybody would commit a felony here, but circuit court judges are the highest level trial judges in Virginia. They're called Superior Court judges in California, North Carolina, and other locations. So if you, not you, but a friend of yours gets, that's the way I usually hear about it, a friend of yours gets arrested, well, what's going to happen? You have certain rights that were afforded to you under the Constitution. The United States Constitution, as Glenn mentioned, was created many years ago. And the way it impacts on you generally is under the Bill of Rights, which are part of the United States Constitution. So you get arrested. Generally, you have 4 rights that come into play. The Fourth Amendment, that every citizen has a right to be free from unreasonable searches and seizures. It prohibits unreasonable searches and seizures. And for our purposes, we have the exclusionary rule. I'm not going to talk about the exclusionary rule at the moment, but that's how it kind of dovetails on you if you find yourself in this unfortunate position. So say you're driving down Virginia Beach Boulevard, and a police officer pulls you over. And perhaps it's something involving your license plate is out of date or whatever. So what can the police officer do? So he comes up and he says, "Can I see your driver's license and registration?" Unfortunately, not you, but your friend is driving and he's smoking marijuana, or had been. And he looks in the rearview mirror and goes, "Oh my gosh, what am I going to do? I'm smoking a joint." And they put it, they try to get rid of it, they put it aside. Police officer comes up, and when you roll down the window, or you try not to roll down the window, the officer smells marijuana. They're trained to smell marijuana. So what happens then? They say, "Can I have see your driver's license registration? Oh, by the way, have you been smoking marijuana?" And you're thinking, well, first, I don't have to really say anything. Well, yes, you do to a certain extent under the Constitution, Fifth Amendment, whatever. It might incriminate you, but he's going to ask you for your driver's license and registration. And then he's going to, once you hand it over, hopefully you have, the friend has a driver's license, hand it over and he says, step out of the car. And what's going to happen next is, because he has smelled marijuana in your car, he can search it. Suppose you don't say anything. Under the Fourth Amendment right, you are, the government, the Constitution prohibits you against unreasonable searches and seizures. Okay, well, is it unreasonable to search the car? Because what the officer now has is what we call probable cause to search the car. Step out of the car. And so he's out, your friend's out, and the officer proceeds to search the car. Well, how much can he search? Can he go into the trunk? Can he go into the glove box?
What's the area in the car?
No, see, no, he knows something. So, I'm not going to go there, but there are all kinds of restrictions. So he can search the car because of the fact that he smelled marijuana. And if he finds marijuana, the next issue is going to be, well, not only is your friend in the car driving, but there are 3 of your other friends in the car. Does he have a right to search them also? Maybe, maybe not. But everybody gets out. They found the joint of the pack of marijuana on the floorboard. But they ask each one of these people, is it your marijuana? Not mine. Or they don't say anything. Now remember, you don't have to say anything. If you're in the back seat, we'll talk about that in a minute, and you don't feel like talking, well, the Constitution says you don't have to. So the officer will then, the officer's just doing his job, don't misunderstand me. But we're talking about search and seizure and the Constitution, how it relates to you or your friends. So they search the car, they find the marijuana on the floorboard, but nobody owns up to it. And so what's the officer going to do? Can he prove in court, coming to my court, actually when you come to my court, because possession of marijuana is a misdemeanor and less than 12 months in jail, it's not a felony offense. They have to decide whether can they prove the case against any one of the 4 people. And then all of a sudden, the driver said, well, the backseat passenger says, okay, all right, officer, it was my marijuana. They had nothing to do with it. So guess what happens? The guy in the back gets arrested because he made a statement. You're saying, well, does he have to make a statement? Well, not really. The Fifth Amendment of the Constitution prohibits the government from actually eliciting this conversation from him. But you're saying, well, what about Miranda? Nobody told him the Miranda rights. I'm kind of jumping around a little bit. The Miranda rights. You're still got parked car. You heard about the Miranda rights. Guy gets pulled over. You have the right to remain silent. Everything you say can and will be used against you in court. You have the right to an attorney if you cannot afford one, and so on and so forth. Well, he didn't advise me of the rights. Well, then it becomes another issue for the court. Well, was he in custody? Was he in custody? Because if you're not in custody, then they don't have to give you the rights. You don't have to. That's your Fifth Amendment right that the Constitution guarantees you. And consequently, the court may have to inquire later, well, was this passenger really in custody? And the officer's going to say, it's true. Well, all I said was, step out of the car. I didn't say, didn't put them in the back room and demand that they make a statement to me. They didn't do anything like that. It was a voluntary statement. And usually these statements are voluntary. So every day in court, we come up with these issues. I'm just using this one example that I just pulled right out of my head. Because what comes into play next? The Sixth Amendment. Now we talked about the Fourth Amendment, which is your right against prohibition. It's a prohibition against unreasonable searches and seizures. And the Fifth Amendment against compulsory self-incrimination. And then you have a right under the Sixth Amendment to a speedy trial, a public trial, and a trial by jury. But there are other Sixth Amendment rights that come into play because of the Sixth Amendment being what I call the court-related part, to make sure that you have your rights as afforded to you under the Constitution of the United States, under the Sixth Amendment, to have these things. So the Sixth Amendment also guarantees you the right to confront witnesses. Under our Constitution, under the Sixth Amendment, you have a right to see who's testifying against you, to look them in the eye, because, when you think about it, it's a big deal. Back in the old days, they could just have an administrative proceeding where there is no witnesses. They just said you were smoking marijuana, or your friend was smoking marijuana when the car was stopped. But the Sixth Amendment prohibits that. So we get what we call so your friend who owned up to the marijuana, he goes to see Glenn Corey, the lawyer. Glenn Carrillo, the lawyer, and lawyer Carrillo says, well, "What happened? Tell me what happened." "Well, I was smoking a joint, driving down Jimmy's Boulevard, and then Dumbo here, the driver, didn't have the right license plate, so they pulled him over, and consequently they searched the car." "Okay, well, did you make a statement?" "Well, yeah, I told him it was mine." So what's a lawyer going to do? Taking our step a little bit further, so you hire the lawyer, or let's just say for a moment that you don't have enough, your friend doesn't have enough money to hire a lawyer. We have so many lawyers, so many people who cannot hire lawyers. We have a fully staffed public defender's office in Virginia Beach and other locations, whose lawyers specialize in representing indigent people. So we go to court, and even though you have the statement made, the marijuana has to go to the lab in Richmond. There's a statement, there's a lab in Norfolk now, sorry, I'm short. The lab report is going to come in as evidence, meaning that the state has to prove that the substance that was taken in the car, even though it smelled like marijuana, looked like marijuana, and it was plant material, not enough. You've got to have a lab report that says it is in fact a controlled substance, i.e. marijuana. And it wouldn't make a difference if it was cocaine or heroin or whatever. Whatever the controlled substance is, you have to have a lab report. So back to my example, we're in court, and the police officer testifies about what I just said. I occasionally be driving eastbound on Jimmy's Boulevard. I observed the defendant, who later was identified as so-and-so and passenger in the car. After I stopped him, he stepped out, and he said that I noticed a green plant-like substance on the floorboard, and I retrieved it, and he said it was his. Okay, so I've got I'm the judge now. I've got a bag of what is supposed to be marijuana, and that's not enough. So the lab report has to come in. Well, interestingly, the U.S. Supreme Court ruled that the procedure that had been used for decades about lab reports, it was no longer any good law, because you had a right to confront your witnesses, meaning, i.e. the lab technician. They had to now come to the court live to testify to the fact that they have examined the substance, and they followed the procedures, and they're educated, they're chemists, they have all these degrees in chemistry, and guess what? It's marijuana! In class 4 controlled substance, if I recall. So, before the U.S. Supreme Court ruled under it's called the Crawford case, if you want to look it up, not that you don't want to, but Crawford versus Washington, Chief Justice Scalia of the U.S. Supreme Court said, lab reports aren't good enough. The U.S. Constitution guarantees that you can confront your witnesses. And so, consequently, before the lab report would come in because state law said it could come in, now it can't come in unless the lab technician comes down and actually testifies. Now, in the real world of circuit court and general district court, you can imagine how many drug charges we have. Most of the time, that evidence is stipulated to. What we say stipulated, Commonwealth's attorney who prosecutes all these cases and the public defender, in my example, is representing the defendant, they just say, okay, we have a chain of custody issue, and we'll waive it. Because defense attorneys, interestingly, you will find this out. Hopefully you friends never get into trouble. But defense attorneys frequently engage in what I call damage control. You go, oh, you know, what do you mean, damage control? Doesn't under our Constitution, say that the state, i.e. the Commonwealth of Virginia, has to prosecute these crimes? Well, yes. And isn't it true that the state has the burden of proof in proving these crimes? Yes. And isn't it true that the defendant, when he comes to court, is what we say cloaked with the presumption of innocence? I always feel like someone's going to come in with a cloak that says interesting on it. That's innocent. Well, that's true. But how difficult is it to prove most of these cases? Because by the time the public defender gets appointed to the case, it's maybe 3 or 4 days later. 3 or 4 days later. So what's happened in those 3 or 4 days? Let's just change our scenario. This time we're talking about robbery. Let's just say that your friend I don't know, standing outside of ECPI, and he decides he wants to get money from you all. I don't know. So let's just say 1, 2, 3, 4, 5, 6. 6 of you on the front row walk out together, and your former friend pulls a pistol and holds up all 6 of you. Give me your money, give me your coffee cup, whatever it is. Hey, look, I've seen cases where they've taken less than that. It's usually a cell phone. But, okay, so I've got my gun out, and I rob all 6 of you. And then you all take out your cell phone, you take out your money, your coffee cups, and I got a big bag, and you're dumping it in there. And guess what? Professor Carrillo, knowing his old police training, he sees a robbery in progress. He calls the police, goes down there, and I'm running off, or my friend is running off with the bag of cell phones, money, coffee cups, whatever. It gets caught. Okay? It gets caught. I mean, it usually happens. It gets caught. And so, all right, now I just counted you all. You said, why is he counting? Because that's important. Under Virginia law, you'd say, well, somebody's going to get charged with armed robbery. You had a pistol, right? Okay. And all 6 of you got robbed. So you're going to be your friend is going to be charged with 6 counts of armed robbery. Each one is 5 years to life. Now we have discretion to suspend parts of that. Now 6 people have been robbed. It's a crime against each person. So using my example, the defendant's taken into custody, but the robbery charge isn't his big problem. You think it should be 5 years to life? That's a lot of time. Well, the big problem is we have another statute in Virginia that's called use of a firearm in the commission of a felony. And what that means is, okay, if I'm convicted of this, the fellow on the end, I'm going to get 3 years for that in prison. The other 5, you're going to get 5 years. 1, 2, 3, 4, 5. All right? Remembering my math, 5 times 5 is 25. Plus 3, 28 years. Okay, 28 years. I can't suspend any of that. That means because I had my friend had what I call a brain seizure, a lapse in his moral judgment. Stupid. I always ask people in court, why don't you do that? I'm just stupid. Just not stupid. You hear that all the time. But I can't suspend any of that. 28 years for robbing the 6 people here. Plus, you've got 6 robbery charges. So right off the bat, using my example, this person's facing 28 years. Now, remember, the police have picked him up, and now he's in custody. And guess what? As under the 5th Amendment, the police have to advise him of their rights. They have the right to remain silent. Everything's taken, blah, 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 blah. We all know the Miranda rights. It's a cultural thing. Everybody knows it. Hopefully. But what does this guy do, your friend do, that almost everybody does? He talks. Why'd you do it? I don't know. I wanted the coffee cup to look good and it just got out of control. I wanted to call my girlfriend in Saudi Arabia and I needed a cell phone. Why'd you do it? Okay, well, all right, so now he's admitted it. He's admitted to 6 counts of robbery, armed robbery, and 6 counts of use of firearm and commission of felony. And guess what? While the police, they said, well, what'd you do with the gun? Oh, I threw it in the bushes. Okay, they go out there. They look out there and they go, oh, there's the gun. Take it out. All right, defendant's transported down to the city jail. So, all right, now this is the first day. So the lawyer gets appointed 3 days later. And he goes to see the defendant. And what does the defendant say? Oh, what are you going to do for me? What are you going to do for me? Well, there's not much to work for here because because you admitted what you did. They have the gun, so all I'm going to be doing is what we call damage control. I'm going to try to get a plea bargain with the counsel's attorney. So you know, the counsel's attorney, he's holding all the cards here because it's your case, your life. And you go, but wait a minute. I've never been in trouble before. Never. I was at the top of my class. And I just had this lapse. Doesn't matter. The judge cannot suspend the 28 years. You're going to prison for 28 years. So my point in talking about how this case usually works is what we see every day. Because all of these constitutional guarantees are really not coming into play. Because the police have acted appropriately, which they almost always do, and you're stuck. Now, using my other example, the example changing the facts a little bit, let's just say for a minute that the defendant, your friend, he robs the 6 people and he takes off in the car. And a couple days later, the police find out who did it. So they go to the defendant's house and they ask him, we understand that you're possibly involved in this case. We want to talk to you. Can we talk to you? The guy says, no, I don't want to talk to you. Well, what do you mean? Well, so you give him the Miranda rights. You have the right to remain silent. Take him into custody. And he doesn't talk. I want to speak to my lawyer. That's one of the guarantees under the Miranda rule. When you think of Miranda, we all hear about the Miranda rule, but we don't really hear about what caused the Miranda ruling. It's the 5th Amendment to the Constitution of the United States about compulsory self-incrimination. So, using my example again, let's just say the pistol is not thrown in the bushes, it's in the guy's house. So, the police say, can we search your house? We hear it's here. We hear the gun's here. You can't search my house. So they want you to hang around and we're going to get a search warrant. So they go see a magistrate, what we call a detached judicial officer, a magistrate, to get a search warrant and search the house. And then they find the pistol. Okay, that sounds fine. But let's just say the police say, I don't need a search warrant. I'm going to search your house anyway. So they search a house and they find the pistol without a search warrant. Or they keep the guy in custody after telling him his Miranda rights, and finally, after a long period of time, he hasn't drank, he hasn't consumed any water, he hasn't eaten anything. He's just said, oh my gosh, I wish these police would just shut up. And so, okay, I did it. All right? So we have an issue under the 5th Amendment, under Miranda. Was that statement really made in a voluntary fashion? Or, no, of course it wasn't. But a judge is going to have to determine that later. Was the search appropriate? He's in his own house. And was there a search warrant required? Yes, of course. So what's going to happen? So now the lawyer has something to work with, right? Fella has, well, he's made a statement. But under conditions that would not be appropriate under the Constitution. And so the defense lawyer is going to file motions with the court, which we call a motion to suppress. A motion to suppress evidence, that's the motion. That's what the lawyers are going to file. They're going to file a motion to suppress to void the statement because it was made in violation of Miranda, Fifth Amendment, and they're going to file a motion to suppress the search under the Fourth Amendment because they were both improper. So a judge is going to rule on it. We're going to hear the evidence. I've heard hundreds, if not thousands, of these motions. So a judge is going to rule. So let's just say he's guilty of sin. We know he did it. We just know he did it. And so the judge hears the evidence, and I decide, based on the evidence, that the statement was not voluntary. So what's going to happen to that statement? It's going to be suppressed. Even though he admitted it, it's going to be suppressed. Cannot be used against him. What about the search? Because they did not get a search warrant under the facts I laid out for you, then the search, i.e. the pistol, is going to be suppressed. Okay, so he's admitted it, number one, and we got the gun. And we can't use either one of them because under the case law, those are what we call the fruits of the poisonous tree. That's right out of the Supreme Court. Fruit of the poisonous tree. So it's not going to come in. So, of course, there may be other issues coming into play. The detective realizing that he made a mistake, perhaps will do something else. He will do something like do a lineup. Have all 6 of these people come down and say, can you identify the defendant in this case? And he looks, and there are, I mean, all 6 of them are looking. Actually, we'll do it separately. And let's just say that the 4 of the people in the lineup are my age, and the 5th person is her age. That's an improper lineup, obviously. Oh, she did it. Okay, done. Well, of course, we're going to suppress that also because it was an improper lineup. So there are all kinds of things that come into play in our court regarding constitutional issues. And as I said, I'm the one that keeps, I'm the gatekeeper, so to speak, because I'm the one that decides who, me or my other judges in my court, will decide whether the statement is going to come in and be used as evidence, or if the search is going to come in because of the evidence that's been produced. So when we talk about the Constitution, it almost always comes into play in court. And I don't know how much history you've had on Constitution, on the United States Constitution, but when the framers did this all these years ago, since it is Constitution Day when they actually signed it, you have all these states, and they were all like separate sovereigns, and they were trying to get together to create the Constitution and to make the United States. Interestingly, most of these amendments, the first 8 amendments to the Constitution, which I kind of printed them out just so that I wouldn't forget. I'm not going to read it to you, obviously. But they only apply to the federal government, not to the states. They did not apply, most of them did not apply to the states until after the Civil War, when the 14th Amendment came into play. After the Civil War, these amendments came into law as far as the states are concerned. Now, we all hear about the First Amendment, which is the right of Congress shall make no law respecting the establishment of a religion. Our history was, of course, that most of the people came out of England to flee. They're fleeing the, I guess, the Church of England at the time, the Catholic Church. So, as under the First Amendment, the state cannot sanction a religion. Well, how does that come into play? Well, we have a lot of litigation on constitutional law as to whether programs, say in Catholic schools, that get federal funds, is that really the establishment of religion? It's litigated significantly. I'm just going to touch on these real briefly. Under the First Amendment, freedom of speech, that I can get up here and say, although it's not true, I can get up here and say our governor or president or a Republican nominee, they're all idiots, right? They really aren't, but I could say that, and I'm free to say that under the First Amendment. Freedom of the press. Why is it that we can read a newspaper, the newspaper man does not, or the TV news or whatever news, they have a right to go out and dig up things to determine if there had been wrongdoing. I mean, let's just say that, I don't know, let's just say that somebody comes to me and he says, Judge, you're going to be hearing the case of so-and-so. Here's $1,000. I want you to dismiss it. Okay, let's just say I take the $1,000. God forbid. I take the $1,000, and it's a regular routine. The defense lawyers would know, okay, you want to get the charge dismissed, then you just have to pay the judge $1,000. Corruption, right? Well, who usually uncovers those things? That's not the state police, it's the newspaper under the freedom of press, because they have this freedom that's guaranteed under the First Amendment. The right of people to peacefully assemble and go out and picket, abortion clinics, whatever. How come they get the right? They have the right to do that. Well, because under the First Amendment, they have the right to peacefully assemble. Now, if they're throwing rocks and cursing and carrying on, and they're not peaceable, then of course the police are going to come up and arrest them. But they have the right to picket. Petition the government for redress of grievances. Okay, you write your congressman or senator or the president. Say, I think what you're doing here is crazy. You have a right to do that under the First Amendment. Second Amendment, I'll read it because it's short, and I think it's interesting. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. They must have been sleep deprived when they wrote this amendment. I mean, really, because there's been so much litigation. Doesn't this make sense? A well-regulated, we're talking about two things. A well-regulated militia being necessary to the security of a free state. Okay, that's one, right? Okay, that makes sense. We got to have a militia. What's the next sentence? The right of the people to keep and bear arms shall not be infringed. Okay, up until about 5 years ago, I think I'm right about this, up until about 5 years ago, there had not been a U.S. Supreme Court decision that said that you had a right to have a gun under the Second Amendment. They decided that 5 years ago that you did. And that's why we have so much litigation now as to different locations are trying to prevent, they're trying to control the spread of handguns or assault rifles or something. But under the Second Amendment, you have a right to bear arms. Now, if you're a convicted felon, you can't have one, and you can't conceal it under our law. But one of the things I do, interestingly, I'm in charge of concealed weapon permits in Virginia Beach. You want a concealed weapon permit, you go to the police department and you're not convicted of felonies or whatever, guess what? You're pretty much going to be qualified to get one. I signed thousands of these things, thousands. Next time you're at a stoplight, somebody flips you off or something, don't take the bait, because I guarantee you there's a good chance they're going to be armed and dangerous, just because of the number of weapons and the proliferation of handguns. I'm not talking about the illegal ones, I'm talking about the legal ones, where people have a right to bear arms. The Third Amendment, that's not, we don't see this too often, I guess not since Civil War. No soldier shall in the time of peace be quartered in any house without the consent of the owner, nor in the time of war, but in a manner prescribed by the law. The Army can't show up and move you out of your house. It's in the Constitution, it's the Third Amendment. We don't hear too much about it. Fourth Amendment, I talked about it already, and just what it says briefly is you have a right to be secure in your person, houses, papers, and effects against unreasonable searches and seizures. And then the last part, no warrant shall issue but upon probable cause supported by oath or affirmation. Using my example about getting a search warrant, the police officer goes to a judge or to a magistrate, usually it's a magistrate, and they have to type out an affidavit for a search warrant, and it gives the probable cause, whatever it is, why that person thinks that there is contraband or something of that nature in a house. And the magistrate makes an independent judgment after hearing all the facts, putting them under oath, that they do or they do not have probable cause. If they do, then he's going to issue a search warrant, which is called for and required under the Fourth Amendment. Fifth Amendment, I talked about that, about my Miranda example. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment of indictment or grand jury, that's right to grand jury, and I'll skip through a lot of it, nor shall be compelled in any criminal case to be a witness against himself. Now you say, well, how is that possible? When using my example about coming to court, let's just say we have a jury trial, which you're entitled to under the Eighth Amendment. Should be the Sixth Amendment, not the Eighth Amendment. My amendment's confused. But I tell my juries all the time about the presumption of innocence. I've got a jury panel coming in, everybody's sitting there, the defendant's sitting there, he's charged with robbery, 6 counts of robbery. And so a jury's going to decide what's going to happen. And I have to tell them, and I tell them over and over again, you understand that the defendant is presumed to be innocent. You cannot assume that he is guilty because he's been indicted and is on trial. Do you understand that? You remember from your government class in 12th grade that we have a Fifth Amendment prohibition against self-incrimination. And then I'll say, it's the government's responsibility to prove the case beyond a reasonable doubt. It's not the defendant's job to prove that he's innocent. Everybody understand that? Forgot it. You understand that the defendant may want to testify, but he does not have to. He doesn't have to testify. And the fact, if he does, and I always say this, I don't know if he's going to testify or not, but if he does not testify, in this case, you cannot hold it against him. You can't. Because under our Constitution, under the Fifth Amendment, he can't be compelled to be a witness against himself. What about double jeopardy? You hear about that? That's under the Fifth Amendment. Double jeopardy. Padrick, what's that? Well, let's just say, using my example, the police charged the defendant with robbing all 6 of these people. And instead, for some reason, I screwed up. Okay, my search warrant is defective, like I said. Or the search was bad, or the statement, the elicitation of the statement, they were all bad. Judge says, you lose, case is dismissed. And so the Commonwealth's attorney and the police officer, they're not particularly happy because they just lost his case. Well, let's try him again. We'll take another shot of it this time because we will try to, we won't make mistakes this time. We'll get a second bite of the apple. Well, under our Constitution, you don't get a second bite of the apple under the Fifth Amendment, under the double jeopardy clause. And then part of the Fifth Amendment is private property cannot be taken for public use without just compensation. Well, what does that mean? Well, it's pretty simple. Let's just say that your house is on Virginia Beach Boulevard, your parents' house or your house. You've owned it, your family's owned it for centuries. It's just right, it's a beautiful house right on Virginia Beach Boulevard. Well, guess what? Virginia Beach Boulevard is going to be widened. And the state needs to take that house for the road widening. So you say, well, they can't take my house because we've lived here for centuries. My family has. Oh, yes, they can, and they will. But you say, how's that fair? Well, under our Constitution, they will have to compensate you for that, your family, under our Fifth Amendment of the Constitution. property's being used for public use, the highway, and therefore, how much is it worth? That's where we come into play, because we have trials in which the only issue is how much that property is worth, how much the homeowner is going to get because the state is taking their property under eminent, what we call eminent domain, and under the Fifth Amendment, how much is that worth? The Sixth Amendment, we talked about that briefly. The accused shall enjoy the right to a speedy and public trial. No locked doors. You want to come to my courtroom and see what's going on, you can come in any time, because it's a public trial. We don't have private trials in America. Some people like to have them private, but they're not. Speedy trial. Using my example, these 6 people, guess what? They all joined the Peace Corps or something. One's in Guatemala, the other one's in Ethiopia. We can't get them here for trial. So what does that mean? Is the defendant sitting in jail forever? No. It means you have a right to a speedy trial. The counsel's attorney is going to have to send a plane down to Guatemala to bring the witness back, because you have a right to a speedy trial under the Sixth Amendment. And I also mentioned you have the right to be informed of the nature and cause of the accusation. I do, usually one day a week, I'll have people that are freshly arrested. Freshly arrested, that sounds funny. Freshly arrested. They're newbies in the jail. So I'm telling them, Judge, I don't know what I'm charged with. Okay, let me get the papers out here. It's usually a probation violation or something. Okay, well, it says you were convicted of possession of heroin, and the probation officer did a urine screen on you and showed you had heroin in your urine. So therefore, you had dirty urine. That's the basis. That is the basis for the probation violation. So you have a right to know that. You can't just be operating in the dark. And I said you got to have the witnesses actually stand in front of you and testify. Look them in the eye. That type of thing. Sixth Amendment. Usually I just call that the Fourth Amendment. And then the Seventh Amendment is the jury trial, the actual jury trial amendment. I keep getting my numbers confused. Where you have a right to not only have a jury trial about your criminal case, but let's just say, using my Virginia Beach Boulevard example, the car behind you is a police car. He doesn't stop you. He rammed in the rear end of you. Whiplash. Get knocked all over. Okay, and you go to the hospital, and and because of that accident, you are severely disabled. Whatever. So, under our Constitution, under the Seventh Amendment, a jury, you have a right to a jury trial on that. A jury will decide how much, if any, money you're going to get. You know, you see that there's the god-awful ads, Wolver, Hammer, Stanley, and all those guys. He's a good lawyer. Not Take Land, he's a good lawyer. But that's what they want. They're telling you your case is worth something. And consequently, come to see us, and we will get you a good result of the jury. But again, it's coming back to the Seventh Amendment. Eighth Amendment, bail. Okay, using my example, I got 6 counts of robbery, never been in charge, never been convicted before of anything, no record. So what happens? The defense lawyer says, I want him out of jail, I want bail. So we're going to have a bail hearing, because under the Eighth Amendment, it says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. I'll get to that part in a minute. So you're going to have a bond hearing, a bail hearing, to determine whether or not somebody's going to be out on bond. Under the Eighth Amendment, some of these provisions do not apply to the actual states. It's one of the Bill of Rights that have not been determined as being applied to the states. Part of it the Eighth Amendment has. But there's a presumption against bail under certain circumstances in Virginia. Some states you can get bail for anything, but in Virginia there are presumptions against bail. Using my example, armed robbery is a good example. The defendant has to show that he can be a good behavior or whatever, and that he's entitled to bail. So anyway, you're required under the Eighth Amendment you're entitled to bail. And we can't just keep you in jail with an excessive amount of bail. Okay, the guy was down in Walmart. By the way, you know, anybody ever thought about shoplifting in Walmart? I'll tell you a little shop story. Walmart, you have any idea how many security cameras they have? But take a guess. How many?
250.
How? 180. 180. Do you know how many theft cases we get from Walmart? Tons. You know why? They're all on video. It doesn't matter if they're in the parking lot or wherever. I guarantee you, every part of that store is covered with video surveillance. Well, I digress. But I tell defendants that. You know, they're charged with stealing from Walmart. I go, hey, do you know how many video cameras they have on at Walmart? Well, I don't know, 5 or 6. 180. Really? Why do you think you got caught? But anyway, I'm digressing. But let's just say you steal a couple of bars of soap from Walmart, worth $10. So the magistrate decides, oh, I don't like your looks. $50,000 bail. Well, that would be excessive, obviously, under the Constitution. So anyway, that's the Eighth Amendment. But the Eighth Amendment also has a prohibition against cruel and unusual punishment. Now that part has been applied to the states. Where does that come in? Death penalty. The death penalty statutes have been evolving, or I should say the case law has been evolving over the years. And the Supreme Court, U.S. Supreme Court, over the last 20 years has severely limited the amount of death penalty cases under the Eighth Amendment. I mean, for example, if you're a juvenile, you commit a crime, a capital crime as a juvenile, can't be executed. Just flat can't. If you have an IQ below 70, I think it's 70 or 80, I forgot, can't be executed. The chemical concoction that they use for the death penalty to put you to death, that part was ruled unconstitutional because of the suffering that the defendants were supposedly having. So again, they have a lot of litigation on that. Under the Eighth Amendment, no cruel and unusual punishment. You know, we can't take you out if you ever go to Williamsburg and you see those stocks where they used to put people in like this. They put them out there for days. You can't do that. Although, you know, if somebody had a choice, I'd say, I'm going to give you 6 months in jail where you could sit in a stock for a couple of days. I guarantee you they'd take that. But they, you know, we just don't have cruel and unusual punishment. And then I'll just talk briefly about the 10th Amendment. It really doesn't mean too much. Well, it means plenty, but for your purposes, all powers not delegated to the United States by the Constitution are reserved for the states. So you hear a lot of talk about state rights and whatnot. That's because under our Constitution, if the Constitution do not spell out that the powers inherent to the federal government, then they're reserved for the state. So that's briefly my little take on criminal law. Real briefly, let's see what else I can tell you. I'll tell you a funny story, I think, from a police story. Talk about bail. When I was a cop, I arrested this guy who was very drunk, I mean, really drunk, combative, and I took him in front of the magistrate. And the magistrate was like this 85-year-old man named J. Clarence Heyman. And he typed warrants like this. There's before computer. And I mean, he looked 85. I mean, he was old as the hills. Type. So I brought this drunk in, and the drunk looks at Judge Heyman, we call him, and he looks over and he goes, "Who is that old son of a bitch?" And without missing a type, not missing a key on the typewriter, and not looking up, Judge Heyman goes, "I'm the old son of a bitch that just denied you bail." Take him in the back. True story. So, if you get arrested, you're always going to be taken in front of a magistrate. Not you, it's your friends. Or the guy that your mom told you not to date. we have a reasonable expectation. I'm going to jump around a little bit. You have a reasonable expectation of privacy in your home. They can't just show up and start snooping around your house. Stop and frisk. Let me talk about it real briefly. We have things like this. Terry, called Terry versus Ohio. It's a case out of the U.S. Supreme Court that said if the police are in a high crime area and see somebody that is acting suspiciously, they can frisk them. Stop them, stop, and stop. They stop, and then what do? Up against a wall. So what are they doing? They're frisking. They're not searching, they're frisking, and they're looking for weapons. That becomes a big issue in court frequently because when is it a frisk or when is it a search? Because they may have a right to frisk, but they don't necessarily have a right to search. Okay, want me to open it up for questions? Sure. Anybody have any questions about anything? I'm a little hard of hearing, so I may have to have an interpreter.
No problem.
Yes, sir.
Morning, Judge. My name is Darrell, business major. The example you used about the defendant in armed robbery, and of course he needed a public defender, so that means he didn't have the money to afford it. Well, if it was a different situation, if that defendant's last name is Rockefeller, DuPont, or Clinton, or his mother's Oprah Winfrey, he ain't going to jail for 28 years as a judge.
Well, now that's a good question. So let's see, now you're talking about favoritism in court. Now, if the more money you have, I think the better defense you're going to get, I think. But I will tell you, our public defenders, in Virginia Beach, if I were in trouble, I would be happy to have them represented because they're in court every day, they know the judges, they know the procedure, they know this, they know that. But using your example, he's admitted to it. If he admits to it, and Mr. Rockefeller calls his lawyer, and the lawyer says, "Have you made a statement yet?" "Yes, I did." "Oh no," but let's just say he didn't. Let's just say it's all proof. Then you're going to have the lawyers filing motions after motions after motion, and it's going to mean a lot of work for the prosecutor. So they may be more inclined to work out a plea deal, but I think there is a little bit of difference between what a rich man and a poor man gets in court, but it's not that much, I think. But it's because of the amount of work that goes into it, because the facts are the facts. You can't change the facts of the case. And by using my other example, they would be filing many motions. Yes.
Why can't the court system go after, like you've seen in the news, especially particularly in Dallas County, Texas, where they're using DNA and they're releasing these guys who've been in prison for 25, 30 years in the 70s and 80s. And a lot of guys weren't angels, but they were convicted of crimes that they didn't do. And now the prosecutors who suppressed information knowingly hid information and evidence.
Okay, now let me just stop with one thing you said. The prosecutors suppressed information. That is a constitutional violation. It's called the Brady versus Maryland. That's the name of the case, not to take your notes. But when I first started in this business, before a lot of you were born, obviously there was no DNA. And a lot of it had to do with eyewitness identification. Like if I got robbed or something, and I would look at pictures later and go, "Oh, that's him. That's him." And swear in 1,000 Bibles that it's him. But it wasn't him. So the jury's going to hear this evidence, and maybe they'll convict him of it. If he's convicted, he gets 20 years prison sentence. And after, say, 18 years, the science has gotten really good for DNA, and they test the DNA and determine it's not the right person. The DNA cases usually come up in sex crimes, because usually there's DNA left in sex crime. But property crimes, usually there is no DNA. I'll tell you what the big emerging area of law is cell phone towers. I've had a lot of cases where they have, the Commonwealth's attorney and the police have tracked people with warrants using cell phone towers to show where they were at a particular time. So it's all kinds of things happening. The science is really revving up and moving along. But in 1980, for example, there was no DNA, there were no cell phones, there was none of that. So I'm not surprised that there have been some innocent people, because we're all human. That's wow, it's a human system. Yes, sir.
Charles Hayden, networking. What about the drones? And
The drones?
Yeah, they're starting to use drones. Well, I don't know about this area specifically.
To my knowledge, there are no drones in this area.
Yes, but they are starting to use them inside the U.S. to surveil, and using drones you can get a lot closer imagery in the houses. Is that going to be infringement on?
Well, that's going to be a constitutional issue because we had there was a case, and I can't think of the name of it, about heat imagery, like where. I'm probably, or maybe some of you know more about this than I do, but the science is that they have instruments that can tell whether or not there are people, or I should say living beings, in a house because they're picking up the images. And I think the U.S. Supreme Court said you couldn't do that without a warrant. I hear somebody who knows something about that.
Kilo first.
Okay. All right, very good.
Sclera.
Okay. But as far as drones are concerned, when you own real estate, technically, you own the land all the way up to the heavens. That's the theory. And there's a lot, way beyond the scope of this class or the amount of time I have to talk about it, but the police can't necessarily just fly over your house with a helicopter and take pictures or whatever. But they can do certain things with helicopters or planes, but frequently they have to have a warrant. They could, say, be flying by and they could see marijuana plants growing, where they weren't looking for a particular house, they just happened to notice it. Then I think that would be okay. But if they had focused in on, say, your house or my house, because they got information that I was growing marijuana or something, then they need a warrant or something. So that's why we have court, because we decide these cases constantly. And I say I have the last word. That's not really true. I'm the last word in the trial court, because if I make a mistake, then we have the Court of Appeals in the criminal case, also the divorces, which I hate, or divorces or whatever it is. We have appellate courts that review what we do. So I'm not really the last stop, so to speak. 99% of the time, I am. And I say I am, I'm going to talk about my part.
All right, we have time for about one or two more questions. Anybody else? This is your opportunity. Don't let it pass.
I got to do a docket shortly, so
No?
I think the law really is fair. Sometimes it doesn't seem fair, but remember, can I just tell you a real quick police story? Miranda. I was a homicide and sex crimes detective, and I interviewed a lot of people. A lot of people who were charged with crimes, and I gave them Miranda warnings every time. And out of all the people I gave Miranda warnings, there was only one person who invoked them. Only one! Which I think is shocking when you think about it, because people have a tendency to talk. And they wouldn't necessarily admit to a crime, they would lie about it. But they would just talk. Talk. And interestingly, the only person who invoked the Fifth Amendment right, when I was doing this for many, many years, was a Filipino Navy chief who gunned down his wife's lawyer. He came home from deployment, found out that his wife was having an affair with turned out to be another Filipino chief next door. So what did he do? He went down to the local gun shop, bought himself a pistol, and knocked on his door. Guy answered the door and said something like, "You son of a bitch," and gunned him down right there. And when I went to interview him, I still remember, with his heavy accented English, he said something like, "Sir, I respect you greatly. However, I wish to speak with my lawyer." I thought, my gosh, somebody actually invoked Miranda. And it had to be this fellow who was really a Filipino national. All right, well, good luck with your studies.
Stay right there, Tom, please.
Good luck with your studies. Happy Constitution Day. I kind of jumped around. procedure, criminal law, constitutional law are courses that take up entire years in law school. So I'm just kind of touching on the basics.
You have already recognized the value
Oh.
of these.
Maybe I won't get robbed outside.
We hope you will be safe. Thank you very much.